Imagine you're doing your regular grocery run, you're walking down the aisle at a Publix supermarket, and out of nowhere, your foot just goes right out from under you.
Oh, the classic slip and fall.
Right. You slip on a puddle of spilled dish soap, you fall hard, and you get genuinely hurt. So, you hire a lawyer, you file a lawsuit, and you fully expect your day in court to make things right.
Which is exactly what the system is there for, right?
Exactly. But what happens when the story you confidently tell the judge, under oath, is completely dismantled by secret video surveillance?
Well, it forces the entire legal system into crisis mode, honestly.
Yeah.
Yeah, because suddenly the court is no longer just deciding a routine case about, whether a grocery store was negligent in cleaning up a spill. The court is forced to decide what to do with a plaintiff who is actively trying to weaponize the judicial process to deceive them.
And to answer that, we're taking a deep dive into a really fascinating stack of sources today. We are pulling from hundreds of pages of trial court transcripts, highly detailed private investigator surveillance logs, and ultimately a landmark July 2026 Florida Supreme Court decision.
The Publix Supermarkets, Inc. versus Goga case.
That's the one. And our mission today is to figure out who actually gets to decide the ultimate punishment when someone lies to the court.
Right, because the Goga decision is really the perfect lens for understanding this hidden balance of power in our legal system.
How so?
Well, it exposes this massive, often invisible tension between the trial judges, the ones who are physically sitting in the courtroom, actually looking at the witnesses, and the appellate courts.
The ones reviewing it all from afar.
Exactly. The appellate courts are reviewing the entire case from, a distance, trying to protect broader legal principles.
Okay, let's unpack this because the timeline of this incident is just wild. Let's go back to that Publix in Pompano Beach, Florida. Goga slips on the dish soap. But instead of leaving the store on a stretcher or, immediately seeking medical attention, security footage captures a very different story.
It usually does in these cases.
Yeah, so she gets up and she just continues her shopping trip. She actually heads over to the wine section, flags down a customer service manager to help her track down a specific bottle of champagne, and purchases it before leaving.
Which, on its own doesn't necessarily disprove an injury.
Really? I mean, she's buying champagne.
Sure. But adrenaline is a incredibly powerful chemical. I mean, people walk away from severe car accidents and only feel the whiplash hours or even days later. So the initial aftermath at the grocery store isn't really the real issue here.
Right. The real issue starts when she files the lawsuit for premises liability. Her claims are incredibly severe. She alleges she sustained major injuries to her neck, her back, pelvis, hip area.
Right, a whole laundry list of injuries.
Exactly. She claims she required 7 months of intensive medical treatment for her spine, and she is going after Publix for everything. We're talking medical expenses, pain and suffering, lost wages.
And as the discovery process drags on over the next 2 years, the legal documents show her claims becoming, hyper-specific about how this fall impacted her daily life.
Yeah, this isn't just a general complaint about having back pain.
No, not at all.
The crazy part to me is that in her written interrogatories and her sworn deposition, she paints a picture of a severely, permanently limited life. She says she can't lift heavy things, she can't walk or stand for long periods.
She even claims she couldn't play in the pool or go places alone with her 2 kids, right?
Yes. When the defense lawyers ask her what she can't do anymore, her exact quote on the record is that there are a lot of can'ts. She explicitly insists that she hasn't lifted her young children since the fall and that she can neither run nor bend at the waist.
And that specificity is exactly where the trap snaps shut. Because Publix didn't just take her sworn deposition at face value.
Thank goodness they didn't.
Unbeknownst to Goga, the defense hired a private investigator. And while all this high-stakes litigation is unfolding, this investigator is covertly recording her daily life.
And the video doesn't just show her having, a random good day. It shows her doing the exact specific biomechanical movements she swore she couldn't do.
Right, the contrast is staggering.
Picture it. She's on the record saying she can't lift her kids or bend down. But the secret video shows her picking up and carrying her children across expansive parking lots.
Just zero hesitation.
None. It shows her bending completely at the waist to load and unload heavy groceries from her car. It shows her playing in the pool. She is doing all of this without a single wince, restriction, or sign of discomfort.
It is a fundamental misrepresentation of her physical reality.
I mean, how common is this kind of total fabrication? And what is a trial judge even supposed to do when faced with such blatant, undeniable evidence of lying?
Well, it happens enough that there is a well-worn playbook for it, unfortunately. When Publix moved to dismiss the case, they pointed directly to a factually identical precedent from Florida's 3rd District Court of Appeal, a case called Willie Kuntz.
Oh, right, the Willie Kuntz case.
Yeah, in that case, a woman claimed a car accident left her with a permanent limp that required a cane, and she swore she couldn't carry large items.
Let me guess, they got her on video too.
They absolutely did. The defense investigator got her on video walking perfectly fine, no limp, no cane, carrying bulky items with zero assistance.
Wow.
The trial court in that case threw the entire lawsuit out, and the appellate court affirmed it, establishing a clear precedent that blatant videotaped fraud warrants the harshest penalty.
So back to our Publix case. Once the defense drops this HD video on the trial judge's desk, the conversation immediately stops being about a slip disc.
Oh, completely. It becomes entirely about the penalty for perjury.
Right. So the trial judge holds an evidentiary hearing, watches the secret footage, listens to Goga try to, explain away the contradictions, and chooses the nuclear option.
And that nuclear option is that the trial court dismissed Goga's entire lawsuit with prejudice.
With prejudice, meaning the case is permanently dead.
Permanently dead. She gets $0, and she cannot refile the lawsuit. The judge ruled that by, quote, clear and convincing evidence, Goga had orchestrated an unconscionable scheme that comprehensively infected the integrity of the action.
But then the narrative takes a really sharp turn when Goga appeals that total dismissal. The 4th District Court of Appeal looks at the trial judge's nuclear option and decides to try and, slice the baby.
They did. They agreed that she lied, but they ruled that throwing out the entire case just went too far.
So how do they split it up?
The appellate court's logic was to separate the subjective lies from the objective facts. So they threw out her claims for pain and suffering and lost wages because those demands relied entirely on her subjective fabricated testimony.
The stuff she lied about on tape.
Exactly. But they reinstated her claims for medical expenses, arguing that medical bills and x-rays are objective evidence that exist independently of her later lies.
And to legally justify reversing the trial judge's punishment, the appellate court used a very specific technical phrase.
Right, the more stringent abuse of discretion standard.
Yes. They claimed they were applying a more stringent abuse of discretion standard. They basically invented a new standard to say, because this punishment is so severe, we are going to scrutinize the trial judge's decision much closer than we normally would.
And that phrase, that more stringent standard, is the absolute heart of the legal conundrum in this deep dive. It determines who actually has the power to run the courtroom.
Okay, to make sense of this, think about this standard of review concept like a sports instant replay.
Oh, I like this analogy.
When a play gets reviewed in a football game, the standard of review dictates how much power the replay booth has over the referee on the field. So some calls, like whether a player's foot stepped out of bounds, are completely objective.
Right, either the foot is on the line or it's not.
Exactly. The replay booth looks at the video and makes their own call from scratch, giving zero deference to the on-field ref. In the law, that's called a de novo review. You start fresh.
Taking that instant replay analogy a step further, you have judgment calls, like pass interference. The replay rules mandate that the booth must defer heavily to the referee who is actually on the field, watching the players collide in real time.
Because they had the best view of the action.
Exactly. The booth can only overturn a pass interference call if it was an egregious, undeniable mistake. In the legal world, that heavy deference to the trial judge's judgment call is the abuse of discretion standard.
So by creating this more stringent standard, the 4th District is essentially changing the instant replay rules in the middle of the game.
They absolutely are.
They are admitting they are supposed to defer to the trial judge's judgment call on the punishment, but because they feel the punishment of total dismissal is too harsh, they are going to act like the replay booth on an out-of-bounds call.
Right.
They are squinting really hard and second-guessing the trial judge's discretion. But isn't that a huge problem?
It's a massive problem for the state's legal system, because suddenly you have the 3rd District Court of Appeal in the Willie Kuntz case strictly following the traditional rules and affirming a total dismissal for a lying plaintiff.
Right.
And right next door, you have the 4th District Court of Appeal in this Publix case using this newly invented, more stringent rule to partially save a lying plaintiff's case.
And the justice system just cannot function with conflicting rules in different geographic districts.
It creates total chaos.
That geographic conflict is exactly why the Florida Supreme Court was forced to step in and take the case. They had to create a unified rule for the entire state.
And they did. Justice Groshans writes the majority opinion, and she lays out a crystal clear three-part framework for how any appellate court should handle a situation where a plaintiff is caught committing fraud.
Okay, let's break down this framework. What's step one?
Step 1 focuses on factual findings. Did the person actually lie? The Supreme Court ruled that appellate courts must review this first step for competent, substantial evidence.
Which means what, exactly?
It's a legal term of art that essentially means profound deference to the trial judge.
Right, and the Supreme Court uses a deeply evocative phrase to explain why they differ on the facts. They talk about the cold record.
Yes, the cold record is such an important concept here.
Imagine an appellate judge sitting in an office miles away, trying to figure out if a plaintiff is lying just by reading a printed transcript of their testimony. That is a lifeless, cold record. You can't see the witness sweating.
You can't see them avoiding eye contact with the jury.
Exactly. You can't hear the slight hesitation or the tremor in their voice. The trial judge, sitting just feet away from the witness stand, absorbs all of that live human context.
And because the trial judge is in a far superior position to evaluate credibility and demeanor, the appellate court has no business second-guessing the physical reality of what happened in the courtroom.
Makes total sense. So what is step 2?
Step 2 of the framework moves to legal conclusions. Does this specific lie legally constitute fraud on the court? Here, the Supreme Court applies your de novo standard. The appellate court gives no deference whatsoever.
So they start fresh.
Exactly. They look at the law fresh to determine if the lies were pervasive enough to count as an intentional scheme to derail the justice system, rather than just, a simple misstatement or a bad memory.
And once you establish the facts and the legal conclusion of fraud, we hit step 3, the sanction. Should the whole case be dismissed or just part of it?
Right, and here the Supreme Court firmly and unanimously rejected the more stringent standard that the appellate court tried to invent.
They shut it down.
Completely. They mandated that the traditional abuse of discretion standard is the only rule that applies. A trial judge's decision on the ultimate punishment can only be overturned if the appellate court can prove that no reasonable person would agree with the trial judge's ruling.
So what does this all mean for our public shopper? When you put those 3 steps together, the ultimate takeaway from the Supreme Court's majority is a massive reinforcement of the trial judge's authority.
It really clarifies the hierarchy of power. The Supreme Court stated that a trial court can only abuse discretion it actually possesses.
Right.
Once the trial judge legally establishes that a plaintiff's fraud permeated the case, that specific judge possesses the ultimate unquestionable discretionary authority to dismiss the whole thing to protect the integrity of their courtroom.
So the appellate court just doesn't have the jurisdiction to step in and play referee just because they think a lesser punishment would have been more merciful.
Precisely. The Supreme Court explicitly stated the 4th District overstepped their bounds by reweighing the evidence themselves.
So they threw out the appellate court's compromise of saving the medical bills.
Yes. They reinstated the total absolute dismissal of Goga's case. $0. Case permanently closed.
Wow. And, reading the majority opinion, the logic feels incredibly airtight. But as with all high-stakes legal issues, it was not a unanimous decision. There is a vital competing perspective in the dissenting opinion that we really have to explore to fully understand the philosophical weight of this case.
That's right, because reading the majority, you're almost cheering for the outcome.
Oh, totally. The plaintiff lied, got caught on tape, and gets nothing. It feels like pure justice. But then you read Justice Labarga's dissent, and he completely flips the script. He comes at this from a foundational constitutional angle.
Justice Labarga anchors his entire dissent in the bedrock of state law. Article 1, Section 21 of the Florida Constitution.
Which says what?
This specific clause guarantees that the courts shall be open to every person for redress of any injury. It is the absolute constitutional right to have your day in court, regardless of your character flaws.
So the dissent is arguing for a much more delicate balance of power. Labarga acknowledges that the system absolutely must condemn fraud.
Right. Nobody is pro-fraud here.
Exactly. But he argues that giving a single judge the unilateral power to throw an entire lawsuit in the trash behind closed doors violates that fundamental constitutional right to have cases adjudicated on their actual merits by a jury of your peers.
And the mechanics of how a trial actually works play a huge role in the dissent's philosophy. The lower appellate court, which the dissent relied heavily upon, pointed out that the judicial system already has built-in mechanisms for dealing with liars.
Oh, like cross-examination.
Exactly, cross-examination and the jury itself. Instead of the judge quietly dismissing the case in chambers, the dissent argues, let the trial happen.
Let the defense attorney stand up in open court and play that secret HD video for the jury frame by frame.
Yes. Let the defense attorney physically confront the plaintiff on the witness stand with their own contradictions. Let the plaintiff be publicly humiliated.
And let the jury themselves decide to punish the plaintiff with a $0 verdict.
The dissent's core belief is that the public theater of cross-examination is the ultimate truth-seeking mechanism. Allowing the jury to see the lie and render a verdict is a far healthier, more transparent mechanism for the justice system than allowing a judge to unilaterally slam the courthouse doors shut before the trial even begins.
But here's where it gets really interesting, though. Playing devil's advocate against the dissent, if we just let the jury sort it out, doesn't that send a deeply dangerous message to future plaintiffs?
Maybe.
Doesn't it tell them, hey, you might as well try lying to inflate your damages? The absolute worst thing that happens is you get caught on tape, the jury gets mad, and you just lose the subjective part of your payout. It basically turns lying under oath into a calculated gamble with no real downside.
And you just nailed the exact fear of the majority. Their entire philosophy is built around neutralizing that exact gamble.
Right.
If the only penalty for attempting to cheat the judicial system is that you get caught and put back to square one, there is zero deterrent against perjury.
So both sides of this Supreme Court decision are fighting to protect the system, just in different ways.
Exactly. The majority is trying to protect the court from being used as a staging ground for fraud,
while the dissent is trying to protect a citizen's constitutional right to seek justice for a genuine physical injury, even if that citizen later makes terrible, dishonest choices during the litigation. And this philosophical tension is exactly why this deep dive matters to you. This isn't just some tabloid story about a woman getting caught on tape carrying groceries when she swore she couldn't.
Right, it's so much bigger than that.
It's a masterclass in how the justice system operates behind the curtain. It reveals how the standard of review, a concept that sounds like the most boring, dry procedural rule imaginable, actually dictates the entire architecture of justice.
It determines whether the ultimate power over a lawsuit belongs to the trial judge, who looks the liar in the eye, or the appellate court trying to preserve constitutional rights from above.
Exactly. The standard of review is the invisible machinery that makes the whole system run.
And understanding how that machinery works leaves us with a lingering, rather provocative thought to mull over, specifically regarding the collateral damage of a total dismissal. We talked earlier about the appellate court trying to save the objective medical expenses while throwing out the subjective pain claims.
Right. The idea that an X-ray is an X-ray, regardless of whether she lied about playing in the pool 2 years later.
Right. So consider the broader economic impact of the Supreme Court's absolute dismissal. If an entire case is dismissed with prejudice because a plaintiff lied about their ongoing pain to get a bigger settlement, what happens to the innocent third parties involved in the case?
Oh, wow.
Imagine a plaintiff who genuinely did slip, genuinely broke their hip, and was rushed to the hospital. They undergo emergency surgery and rack up massive, completely objective hospital bills long before the thought of a fraudulent lawsuit ever enters their mind.
Then, 2 years into the litigation, they get greedy, they lie in a deposition, the private investigator catches them, and the judge nukes the entire case.
If the court shuts the door completely, leaving the plaintiff with absolutely nothing, the plaintiff obviously can't pay those medical bills. So do those innocent doctors, surgeons, and hospitals simply go unpaid. By choosing the nuclear option to protect the court's integrity, does the ultimate sanction for fraud accidentally punish the very healthcare workers who actually provided the real objective care?
Wow, that casts the clean and logical total dismissal in a completely different light, protecting the integrity of the courtroom, might inadvertently bankrupt the innocent bystanders of the plaintiff's deception.
It really just proves that in the legal system, the solution is rarely as simple as it seems on the surface.
It really does. Well, we want to thank you so much for joining us on this deep dive. Keep questioning the systems around you. Keep looking for the real rules operating behind the headlines. And next time you're walking down the aisles at Publix, maybe watch your step around the dish soap.
We'll see you next time.